Hi Professor, my name is Jia Hao. Today I'll be discussing the Latium maxim Qs is solium use is usqual et quodam id et inferus, which means he who owns the land owns everything up to the heavens and down to the depth of the earth. Traditionally, this maxim represented the three-dimensional nature of land ownership in English law. As Kevin Gray and Susan Francis Gray explained in Element of Land Law, this maxim historically illustrates the vertical extent of land ownership in English law, encompassing surface, subsoil, and airspace. However, the note that while the principle established a clear conceptual framework for ownership, its practical application has always been subject to limitation imposed by reasonable use and technological developments. This scholarly perspective provides a foundation for understanding how subsequent cases and statutes have restricted the maxim in modern law. According to Section 205(14) of the Law of Property Act 1925, land includes mines and mineral buildings and other corporeal hereditaments, which confirms that ownership extends beyond the surface. However, modern developments such as aviation, underground drilling, fracking, and digital surveillance have forced both the courts and parliament to reconsider the scope of this principle. Today, it functions as a qualified presumption rather than an absolute rule. In this presentation, I will critically evaluate its relevance in modern English land law by examining both airspace and subterranean ownership, focusing in particular on the Denmark case Bocado SA versus Star Energy. Let's begin with the air above the land. In the lower stratum of airspace, the maxim still carries significant weight. In Kelson versus Imperial Tobacco, a signboard that projected only a few inches into the claimant's airspace was held to be a trespass. Similarly, in Ancho Brewhouse versus Berkeley House, the overswinging arm of a crane was actionable even without physical damage. These cases demonstrate that English law protects the lower airspace to such heights as is necessary for the ordinary use and enjoyment of the land. In other words, ownership of the immediate airspace remains strong, and any unauthorized intrusions can amount to trespass. However, the position changes when we move higher. In Bresson of Light versus Skyviews, Griffith J. rejected the literal reach of the maxim and held that ownership does not extend indefinitely to the heavens. Instead, the court introduced a test of reasonableness, limiting the land's owner right to a height necessary for the ordinary use of the land. This principle was reinforced by Section 76 of the Civil Aviation Act 1982, which exempts lawful flight from trespass or nuisance liability. So, while the maxim remains conceptually useful, its practical scope in the upper airspace is restricted. Landowners cannot claim rights against overflying aircraft or other legitimate activity conducted at high altitudes. Therefore, the maxim continues to provide a conceptual foundation for airspace rights, but in practice, those rights are limited by reasonableness and public policy. The dense owner vertical columns of ownership still exist in theory, but technological progress and statutory interventions have significantly constrained how far that columns can reach into the sky. Now, let's move underground, and this is where Bocado versus Star Energy becomes especially significant. In this case, Star Energy drilled diagonal wells from neighboring land to reach petroleum reservoirs located about 800 to 2,900 feet below Bocado's property. Although Star Energy held a government license under the Petroleum Act 1990 Act, it had not obtained Bocado's consent. The key question for the Supreme Court was whether this ruling amounted to trespass beneath the surface, and if so, what level of damages should be awarded. The Supreme Court held, by a majority of 3-2, that Star Energy's action did constitute trespass. The company's government license authorized extraction of oil, but not the act of passing through private subsoil without consent. However, the damages awarded were only £1,000, calculated under the Mines Working Facility and Support Act 1966, which bases compensation on what is fair and reasonable, not on the value of the oil extracted. Lord Hobbs reaffirmed that the maxim still has value in English law, but ownership only extends to a practical depth, not infinitely. So, the court formally recognized Bocado's ownership but granted minimal compensation. In other words, formal recognition did not mean reasonable compensation. The Bocado judgment both revived and weakened the maxim. On the one hand, it confirmed that freehold ownership includes the subsule and that the right to exclude remains legally valid. On the other hand, the nominal damages significantly diluted the economic substance of ownership. The trespass was real, but the remedy was trivial. From a property rights perspective, that undermines the core of ownership. The right to exclude should normally carry significantly value. Yet from a policy perspective, the decision makes sense. It prevented landowner from demanding excessive ransom payment that could obstruct national energy production. Ultimately, the court preserved the form, but weakened the substance of the maxim. It became a principle recognized in theory, but hollow in practical effect. After Bocado case, Parliament went even further to limit private control over underground space. The Petroleum Act 1990 Act vests ownership of petroleum in the Crown, meaning landowner cannot claim the oil itself. The Mines Working Facility and Support Act 1966 allowed access to private land for energy infrastructure based on fair value compensation. Then came the Infrastructure Act 2015, Section 43, which grants an automatic right to use deep-level land below 300 meters for petroleum and petroleum operations. Such use is not considered trespass. No compensation is payable. This creates a layered system that the shallow subsule remains protected by Bocado, but deep strata are governed entirely by statute, where private rights are displaced by the public utility. Legal scholars have highlighted these parallels in modern land law. Elaine Chu, in a 2017 article, argues that underground development has forced the common law to abandon the idea of absolute subterranean control. She explains that infrastructure demands a model of shared occupation rather than singular ownership. Similarly, Laniu Getty observes that the maxim now plays mainly a conceptual role. Landowners retain nominal rights in airspace and subsule, but actual control is limited by statute and public interest. So, Bocado shows how modern law maintains the rhetorics of private ownership while subordinating it to collective needs. In short, the maxim survives in doctrine but not in economic reality. It shows a clear policy evolutions, from Petroleum Act 1990 Act to the Infrastructure Act 2015 and the Land Restoration Act 2002. The law constantly narrowed the absolute scope of ownership to promote certainty, developments, and public interest. In particular, the Land Restoration Act 2002 provides a formal framework for regulating both surface and subsurface rights, including stratified ownership of buildings and underground infrastructure. This ensures that three-dimensional property rights are recognized, identifiable, and enforceable, while also limiting the scope of absolute ownership in practice. English land law has thus evolved from a model of absolute ownership to one of regulated stewardship. Landowner delays are no longer sovereigns over a vertical domain stretching from heaven to hell. Instead, they are custodians operating within a system that balances private rights with social and technological progress. When comparing airspace and subsule, we see the same transformation. In the air, ownership up to the heavens has been limited to reasonable height, and lawful aircraft are exempt from trespass. Beneath the ground, ownership down to the deep has been recognized by Bocado, but restricted by Crown's ownership of petroleum and statutory exception below 300 meters. Across both realms, the maxim have shifted from a statement of absolute vertical dominance to a functional policy-driven principle. It survives as a doctrinal skeleton reshaped by regulations and practicality. To conclude, the maxim cues its solemn use its usquo et collims it et inferus remains foundational yet fictional in modern English law. In airspace, it has been limited by technological necessity and public interest. In subsule, Bocado reaffirms ownership in principle but eroded it in substance, while subsequent legislations eliminated even nominal trespass at great depth. As Chu and Getty both point out, the maxim today functions more as a legal metaphor than as a binding rule, a symbolic reminder that land is three-dimensional, but the ownership is subject to reasonableness, statutes, and social need. English land law has moved away from feudal absolutism towards a modern balance, a world where private rights consist with collective purpose. and where formal recognition no longer guarantees meaningful conversation. And last, thank you for Professor listening.